Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
The defense will stipulate to the competency findings, Your Honor.
Okay. All right, pursuant to the stipulation of counsel and the report filed by Dr. Gaisley, I'm going to find that Mr. Green has the ability to understand the nature and objectives of the proceedings. What's the date of this report?
The date of the report, Judge?
Yeah.
July 15th of 2025.
Do you have a copy of that?
Do, Judge.
All right, so this is Dr. Vanderkar, correct? Mr. Mulkey?
Yes, Your Honor.
All right, so based on that report, I'll find that he is capable of assisting, capable of understanding the nature and objectives of the proceedings, and that he is capable of assisting in his defense, so I'll find that he's competent to stand trial. All right. Mr. Mulkey, what's your pleasure here?
Thank you, Your Honor. Having found that he's competent, Your Honor, my client has indicated to me today that he would like to accomplish a change of plea on this case. I've gone over his plea paperwork with him. He's indicated an understanding of that paperwork, and I anticipate that a plea is forthcoming. And then when appropriate, we would just ask to be briefly heard on his state of bond, Your Honor. Thank you.
All right, Mr. Green, how old are you?
35.
And how far did you go through school?
I got a GED.
Are you a United States citizen?
Yes.
Are you able to read, write, and understand the English language?
Mm-hmm.
All right. Prior to coming to court, have you taken any drugs or prescription medication in the last 48 hours?
This medicine they prescribed me, diagnosed me with, but I haven't had any drugs.
When's the last time you took the medicine?
Yesterday, early this morning.
All right. Does it affect your ability to understand what we're doing here? You understand what we're doing here?
What are we doing here? What are we doing?
Do you understand what we're doing here?
We're in court. What are we doing?
Right. Well, my understanding is you're going to plead guilty to strangulation, a felony of the 3rd degree, and then assault, a felony of the 5th degree. Is that your understanding?
That's what we're talking about, yeah.
Is that what you talked to Mr. Mulkey about?
Right.
Okay. All right. Did you get a copy of these charges?
Here's one right here. Here's one right here.
All right. All right. Now, so is it your intent to plead guilty to those 2 charges?
Yes.
All right. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights that you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you some questions. If you don't understand a question, stop me and ask me again, or if you want to talk to Mr. Mulkey some more, let me know, and I'll give you more time. You understand that?
Right, right.
All right, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Right.
Are you waiving that right?
No, I'm not.
Okay.
In order for the guilty plea to go through, these are the rights we're giving up to a trial. So if you want to waive that right and go through with the guilty plea, you have to say yes. If you want to give up your right to a trial, if you don't want to have a trial, you have to say yes. That you understand you're giving up the right. Do you understand that?
No, I don't understand.
You don't want a trial, right?
No.
Okay, so you want to waive the jury.
Okay.
So when he asks you these questions, you would say that you do understand that you're giving up your right to a trial by jury.
Okay. All right. Was I supposed to say yes? I'm giving them my right or whatever. I mean,
Are you going to waive your right to have a trial?
you told me to say yes.
Is that what you want to do?
I guess so. I said no, but I guess I have to say yes.
No.
Well, it depends. If you want to plead guilty, then before we do that, okay, before I let you do that, I have to go through all the rights that you have with these charges. Make sure you understand that you have those rights. And if you want to plead guilty, you have to acknowledge those rights and then waive those rights. Okay, so that's why I'm asking you these questions. So you have a right to have a trial, either to a jury trial or a trial to me. Do you understand that? You
Right,
understand you
yeah,
have that
yeah.
right?
Right.
Okay, are you going to waive that right?
He told me to say yes, so
I know what he told you to say, but I don't care what he told you. I need to know what you want to do.
I'm not understanding it.
Okay, why don't you take a little time?
All right,
Mr.
thank you, Judge.
Okay, I'll be back. Let me know. Here, Lisa, you can have that back.
Do you want this one, or you have it?
Yes.
Are you waiving that right?
Yes.
All right, now, if you went to a jury trial, all 12 members of the jury would have to agree to a guilty verdict before you could be found guilty. Do you understand you have that right?
Okay.
Do you understand that?
Okay.
Now, do you understand it? You gotta say, if you're shaking your head, yes, but she can't write that down. She's gotta write down words.
Yes.
All right. Are you waiving that right?
Yes.
If you go to trial, then the prosecutor is going to call witnesses who are going to testify against you. Do you understand that the prosecutor has to prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, after the witnesses are done testifying for the prosecutor, then you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Okay.
Do you understand that right?
Yes. Yes.
Are you waiving that right?
Okay.
Well, okay, don't tell me if you're going to waive it. You're going to waive it?
If that's what to do.
Huh?
That's what we're doing.
I know, but is that what you want to do?
I'm trying to ask you about probation. I don't know all this stuff you taking me through. You took me through competency. I had to go to classes for that. That's how I'm found competent now. I don't understand. Every time I come to your courtroom, it take a long time for me to be released. I'm trying to do the best I can in here, man. I don't understand. I said okay. This yes. What that supposed to help? Your court process take too long every time I meet you, man.
Hey, the other 3 places take a lot longer than I take. But I got to make sure that you understand that when somebody pleads guilty, you or anybody else, I have to make sure they understand all these rights they have, because if you understand the rights and you waive those rights, then you're going to plead guilty and then you get convicted. Okay, if you don't understand them, then I can't get to the next step of asking you what your plea is. So that's why we're going through these questions.
All right.
And if I ask you if you understand the right, and if you're going to waive it and you say okay, that don't really tell me nothing. Okay. But listen, you can do whatever you want to do. If you want to have a trial, you can have a trial. If you want to plead guilty, you can plead guilty. But if you're going to plead guilty, you got to understand what these rights are and waive these rights. Now, where we got bogged down here is once these witnesses come in and testify for the prosecutor, then your lawyer has the right to cross-examine the witnesses. Do you understand that you have that right to have your lawyer cross-examine the witnesses? You understand that?
Yes.
Are you waiving that right?
Yes.
Okay. If you go to a trial, then you have the right to bring witnesses in here to testify for you. Do you understand you have that right?
I don't have any witnesses to bring in here and
Well,
help me
but
fight.
let's say you did have one and you wanted to bring him in. You have that right. Do you understand that?
Yes.
Okay, you're going to waive that right.
Okay, yes.
All right. Now, if you had a witness and you wanted them to testify in your trial and they didn't want to, then I would make them come in here and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
Okay, if you went to a trial, you would have the right to testify if you wanted to. Do you understand that right?
Okay.
Yes?
Yes.
Are you waiving that right?
Yes.
Okay. And then if you had a trial and you decided you didn't want to testify, you have that right. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
Now, if you decided not to testify, if you went to trial and you decided not to testify, nobody could say anything about that. Do you understand that?
Yes.
All right, if you went to a trial and you got found guilty during the trial, you would have the right to appeal that finding. Do you understand that?
Yes.
All right, and are you going to waive that right to appeal a guilty finding?
So, I guess so.
If you filed an appeal, if you went to trial and you lost and you filed an appeal, you would have the right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
And if you couldn't afford a lawyer, you would be given one at no cost. Do you understand that?
Yes.
And then if you went to a trial and were found guilty, you would have a right to have a transcript of all the hearings in the case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
And if you couldn't afford a copy of those transcripts, they'd be given to you free. Do you understand that?
Yes.
All right, so if you plead guilty today, you don't have the right to appeal the guilty finding. Do you understand that?
But I'm still gonna come to court the next time and it's gonna be sentencing, right?
Right.
Yes.
Okay. All right, do you have any questions about any of these rights that we just went over?
No.
Do you still want to plead guilty to these two charges?
Yes.
Do you understand that by pleading guilty, you're fully admitting your guilt in these charges?
Yes.
Do you understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control? You understand
Yes.
that?
Yes.
All right. In count 1, strangulation is a felony 3. There is a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes.
In count 2, the assault, it's a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
All right, now I could give you a consecutive sentence. That means one sentence after another. And if I did that, then there's a maximum prison sentence of 48 months and a maximum fine of $12,500. Do you understand that?
Yes.
he's not on PRC, right?
I don't believe that he is. You're not on parole. Oh, no, he's not, Your Honor.
All right. Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, then you're going to have to serve a period of post-release control after you get out for at least 1 year up to 3 years under the parole authority? You understand that?
Yes.
They would put conditions on you. If you violated their conditions, they could send you back to prison for up to 9 months for each violation, up to 1/2 of the sentence I give you. Do you understand that?
Yes.
If the violation were, if the post-release control violation were a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And the penalty for that would be either 12 months or the time you have left under post-release control, whichever is more. Do you understand that?
Yes.
Do you understand that if a prison term is imposed on you, you are eligible for judicial release?
What's judicial release?
That means if I sentence you to prison, I could let you out early and put you on probation. You
Yes.
understand you're eligible for that?
Right.
All right. Now, I could put you on community control for up to 5 years, but if you violated any of the conditions, I could send you to prison for a maximum of 48 months. Do you understand that?
Yes.
Now, has anybody told you I would go easy on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Now, at the time of sentencing, the prosecutor may make a recommendation. Mr. Mulkey could make a recommendation. You understand I don't have to follow either of those recommendations.
Okay. I don't understand. It sounds like it's against me.
Well, no. They could make a recommendation. Ms. Naroda could make a recommendation that I should sentence you to whatever. Mr. Mulkey could make his own recommendation. I don't have to listen to either of them. Do you understand that?
Okay.
Now, have you had enough time to talk with Mr. Mulkey before pleading guilty here today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with his advice?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions for me?
No.
Ms. Naroda, if the case went to trial, what would the evidence show?
Your Honor, had the state proceeded to trial, the state would have brought forth the following facts, and that was on May 28th of 2024. Mr. Green was in the Lake County Jail. Corrections Officer Cody Lehman was the CO that was in charge of the range he was on. During Officer Lehman's shift at mealtime, Mr. Green wanted to step out of his cell. Corrections Officer Lehman did not want him to. Corrections Officer stepped towards Mr. Green to prevent him from exiting his cell. A tussle ensued. As a result of that tussle, the corrections officer suffered minor injury to his neck and shoulders, and his breathing was impacted.
Okay.
And face, also he had some abrasions on his face.
All right, Mr. Mulkey, anything to add to those facts?
No, Your Honor. Thank you.
All right, Mr. Green, did you hear what Ms. Naroda said that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes.
What's your plea to count 1, strangulation, a felony 3?
Guilty.
What's your plea to count 2, assault, a felony 5?
Guilty.
Mr. Mulkey?
Sign it here.
judge, I'm handing you the written plea of guilty. Mr. Green has signed that document in the presence of Mr. Mulkey as well as myself on behalf of the state.
Okay, Mr. Green, did you sign that written plea of guilty document?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was with Mr. Mulkey, advised of all of his rights, made an knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty and find him guilty of count 1 strangulation of felony 3 and count 2 assault of felony 5. I'm going to refer this for a victim impact statement. Sentencing will be August 7, 2:15 p.m. Mr. Mulkey?
Thank you, Your Honor. I think at this time we'd like to be briefly heard on bond, Your Honor. My client indicates that he would like to go to Project Hope as a place to stay. He indicates he would he'd come to his court date, Your Honor. I know our sentencing is set for August 7th. If there is any way to expedite it, that would be good. Otherwise, Your Honor, we will defer to the court as to a decision for continued incarceration. But we just ask the court to take all of that into consideration. He's been through quite a bit with his medication and his restoration to competency, Your Honor. So we're just trying to keep the process moving for Mr. Green.